90% of the time, I can talk to a defense attorney and say, this surgeon did nothing wrong. This is how I would treat it. This is standard of care. I have lots of data to support this literature, but it's a business decision.
Let's go back a little and talk about your own experience with being sued as a doctor for medical malpractice.
If I'm the doctor that did this, did I fall below the standard of care? I get asked about this all the time in my own depositions. Well, Dr. Cohen, you've had experts against you say you fell below the standard of care. Yes, they did. So you disagree with them? Yes, I do.
Hello and welcome to On the Stand. I'm Ashish Arun, and this is the show where we talk with expert witnesses who help bridge the gap between complex technical knowledge and the legal system. Today's guest is Dr. Stephen Cohen. He's a board-certified colorectal and general surgeon, an educator, and a medical legal consultant with over 30 years of experience. Dr. Cohen teaches at Virginia Commonwealth University, practices full-time at the Richmond VA Medical Center, and regularly consults on medical malpractice cases, working with both plaintiff and defense attorneys. He also serves as Chief Medical Officer at Calivar, a platform that's rethinking how expert opinions are sourced in early-stage litigation. In today's conversation, we'll talk about what it really means to be an effective expert witness and what's changed in the intersection between medicine and law. So let's get started and welcome Dr. Cohen to the show. Dr. Cohen, welcome to the show.
Thank you so much. I'm looking forward to being here.
I'm looking forward to having you and, talking to you about being a doctor, being an expert witness, and obviously Calivar. So let's get started. You're a board certified colorectal surgeon and a sought after medico-legal consultant. So when did you first recognize that your clinical practice could actually serve the legal system?
Yeah, it's a great question. I actually got into it accidentally. So I started after my surgical training in Boston and then colorectal training in Fort Lauderdale. I joined two other colorectal surgeons in private practice in 1994. And it was at that time that my senior partner asked me if I'm interested in reviewing a case. And I had no idea what that meant. I said, okay, what does that mean? He says, your attorney, there's a patient had a complication, and he didn't know the details at the time, but patient has a complication. They want you to look at the chart in retrospect, right? Because it always happens after the fact. And you tell the attorney if you thought the provider, in this case, a surgeon, either met or didn't meet the standard of care and what that means. And if the provider did not meet the standard of care, did it cause any harm? And that's how I got started. And then as the years went on, they like the fact that I was able to explain complex medical issues to somebody with a fifth grade education, because that's really what you have to do.
Yeah, that was actually going to be my next question, because many people, and including experts, they struggle to make complex topics accessible. In fact, a major criticism of some experts is that they're snooty, they talk in jargons, they get too technical, and they're kind of showing off. Now, that is more in the jury setting when you're testifying. So we'll come to that. But even at the pre-litigation stage, and I believe you do pre-litigation assessment as well. So when attorneys are trying to understand that, was there really, do I really have a case? Or on the defense side, does this case really have legs? And you said that you are able to do that. You're able to explain it like you can to a 5-year-old. So what personal philosophy or communication techniques do you use when you are testifying or reviewing these cases and you're trying to explain them in layman's terms?
Yeah, and that's a great question. And you're exactly right. The smartest doctors in the world doesn't necessarily mean they're going to be an expert witness. Medicine is not the same as law. I don't know the law, but the thing that I know is the medicine. And I think for me personally, it comes from my background as my mother being a school teacher. And you've all been through classes, right? Through high school and college. You have good teachers, bad teachers. How do they explain it to you? If I can't explain it to you in a way that you understand it, then I don't understand it, right? So for the past 30 plus years, I've always been involved in the teaching, training, and educating medical students and residents. So to me, if I'm talking to an attorney on the phone about the initial consultation about a case, or I'm in front of a jury, it's no different than what I do on an everyday basis when I'm talking to the residents and medical students. They may have never done a case before. Can I take them through it? Can I explain why I do it? Can I explain the complications? So you have to put yourself in the position of talking to individuals that have no medical background, which is most juries, obviously, and limited knowledge from the attorneys. Because again, they're very good at the legal issues and the nuances of how to get the case to court. But in terms of the medicine, that's where they rely on us. And that's the only way this system works, is if you have well-trained, educated, experienced physicians that do this on a day-to-day basis to explain to the jury, to the court, to the judge, to the attorneys exactly what we do.
Will you take me into your background as a surgical expert? And, like what kind of cases are you usually working on? And what issues do you look at? And how is your role as an expert crucial for attorneys on both the plaintiff side and the defense side when they bring you in the pre-litigation stage?
Right. So as you know, and most people listening to this recording also know, is that if I would only get asked to opine on standard of care in a surgeon like me, so a general surgeon who maybe took out the gallbladder, took out the appendix, or a colon and rectal surgeon that does a colonoscopy or does anorectal surgery, you can only, the definition of standard of care is what a reasonable, prudent physician, similar physician would do on a similar patient in the similar circumstances. So I can't opine on standard of care of an ER doctor. I'm not an ER doctor. I can't opine on the standard of care of a nurse. I'm not a nurse. So the cases that I get asked to review are a surgeon, usually if it's a standard of care question, perforated colonoscopy, anorectal surgery that went wrong, a sepsis case, bowel obstruction, post-op bowel surgery that for 3 days the patient becomes in septic shock and nobody thinks about, we better rule out the leak at the colorectal anastomosis. We all know that's a common complication. I will tell you in general, I'm usually not critical of the complication. We all get complications with surgery. And I tell the residents this all the time. If you have a surgeon that says they never had a complication, either they're lying or they're not doing enough surgery. So it's okay to have the complication. And I've had almost every complication that's out there. However, what I'm critical of is the failure to recognize that complication in a timely fashion to prevent the harm. Some things are not preventable. I can give you all the antibiotics before surgery. You may develop a urinary tract infection. But if I recognize it and treat it, that's fine. Leak at the anastomosis, when we take out a piece of bowel and hook it together, 7 to 12% of the time, it's going to fall apart. That's in the best surgeons in the world. There's lots of data to support that. I'm not critical of the leak. I've had plenty of leaks. But if the patient is not progressing normally, they have an elevated white count, they have renal failure, they're tachycardic, you need to rule out the leak. And if you don't rule out the leak and you get septic and die, it's the delay in the recognition that's the most common thing that I'm asked to opine on.
And so you've been on both sides of the paradigm of medical malpractice. You work as an expert witness, and I believe you have a very balanced, almost 50-50 plaintiff defense ratio. And so do you have a comment on that?
Yeah, so it's very interesting. So in general, it's about, I get asked to review about 50% from a plaintiff, 50% from the defense. Sometimes I can't remember who hired me. I know that sounds silly, right? But I can get a call today about, are you willing to review the case? Sometimes it's a paralegal. They don't even know all the details, right? Yeah. I just need to make sure I'm able to opine on it. It's my specialty. And that I don't have a conflict. I don't know the physician. Yeah. I don't know the hospital. But then it can take 6 to 8 weeks for them to get me the records. And I don't remember. And I'll tell you a funny story that happens to me a lot. Recently, I called the attorney after 6 weeks of the initial phone call. I reviewed the chart. And I told the attorney, I said, look, I can't really tell you the physician fell below the standard of care. Everything was perfect. And the attorney said, I'm the defense attorney. I'm glad you said that. Right. So it's very important. And again, someone who's been sued himself,
Yeah.
you cannot look at these cases in hindsight.
Mm-hmm.
I always get criticized that I do that, but I don't do that. I pretend I'm standing at the bedside on postoperative day number 2. I know the patient had surgery. I know my labs. I know the x-rays. What would a reasonable, prudent physician do?
Yeah.
So you can't look at it in hindsight. And I say this all the time. Outcome is irrelevant in standard of care. I can do everything right and have a bad outcome, right? Mm-hmm. I can do the wrong thing, not on purpose, but there are physicians that might do the wrong thing and there's no bad outcome. Yeah. If you tell me you're allergic to penicillin and I accidentally give you penicillin, but you don't have a reaction, well, that's not a bad outcome, but it's not standard of care. Shouldn't give you something. You tell me you're allergic to it. Yeah. So, and that's a silly analogy, but outcome is not relevant in standard of care. And you need to look at these cases going forward. But back to the question about the breakdown of what I review, I get asked to review about 50% plaintiff, 50% defense. But if you actually look at my last 5 years of deposition and trials, it's closer to 70% plaintiff, less for the defense. Why is that? Most cases settle. Yeah. 90% of the time, I can talk to a defense attorney and say, this surgeon did nothing wrong. This is how I would treat it. This is standard of care. I have lots of data to support this literature, but it's a business decision, and they decide to settle. So there are a lot less depositions and trials on the defense side, despite me jumping up and down and saying, don't settle, versus on the plaintiff side.
Let's go back a little and talk about your own experience with being sued as a doctor for medical malpractice. So how was that? Can you talk, can you tell us about your experience going through the process as a defendant and how that did that shape your thinking as an expert witness? Does that shape your thinking as an expert witness today? And how has that, and how does that compare to the experience of being an expert and looking at defendants who are being sued?
Yeah, so the way I look at it, I mean, certainly most physicians, the chance of all of us getting sued is very high. Yeah. The first one is the hardest one because you really feel like you're the worst doctor in the world, right? What did I do wrong? I thought I did everything right. So the first one's the hardest. It's a lot easier to be the expert witness when you're not emotionally involved than to be the one sued, for sure. But you're exactly right. It's very much shaped when I'm talking to a plaintiff attorney because I pretend like that's me, right? If I'm the doctor that did this, did I fall below the standard of care? So there's no gray zone when I'm testifying. It's based on the facts, what a reasonable, prudent physician should do. And I get asked about this all the time in my own depositions. Well, Dr. Cohen, you've had experts against you say you fell below the standard of care. Yes, they did. So you disagree with them? Yes, I do. I had plenty of experts on my side that say he did everything right. It's a bad outcome. But I hate to say this, but I have said this before. In the medical legal world, on many occasions, the truth does actually not matter. I know that sounds silly. It sounds silly every time I say it, but there's no downside for a plaintiff attorney, and I'm not picking on them because I have a lot of friends that are plaintiff attorneys, to go ahead and sue the doctor because they know. If I'm a plaintiff attorney, I know 90% of the time the case is going to settle. I know that, right? So there's no downside to file the suit. A lot of times they make the client or the patient pay out of their funds for the initial retainer to find their expert witness. I have read so many depositions of expert witnesses on the opposite side of me, even some of the ones testified against me, that bald-faced lie under oath. But nothing happens. What happens if you lie under oath? Well, you can lose your fellowship status in the American college. That's one thing, but so what? You can't lose your board status. Nobody can tell you not to do it, right? So it can be very disheartening to see another provider or physician lie under oath, but I've seen that many times. And the truth doesn't matter. Plaintiff attorney knows most of them are going to settle.
Yeah.
However, and this is a good news for the physicians, if and when you go to trial as a physician, 87% of the time, it's going to go in your favor. Believe it or not. Most juries don't want to find against the doctor. So it is hard to win a plaintiff case if you actually go to trial. The odds are stacked against you. But that's why I say sometimes the truth doesn't matter. If the other side can win on a technicality, it's a win.
And then there's also the whole cost of going through litigation.
Right.
Like
It's
vis-a-vis
extremely costly.
Like if you are able to settle, then okay, the settlement's confidential. The the record will be there that you were sued if the case gets filed, and then the docket would reflect that the case settled, but the settlement amount is usually confidential, and it saves
is.
you.
I mean, you could find it, but it's a lot cheaper for the insurance company to settle for 100, 150, 200, 5,000 than to lose the 16, 20, or $25 million case, which I was in a trial about a year ago. It was a failure to recognize a leak at the anastomosis, and they tried, and I'm on the plaintiff side, and the defense wanted to settle for $2 million. This was a 54-year-old gentleman that should not have died. And it's very interesting. The defense surgeon actually could not find an expert to defend him, so he defended himself, which tells you something. Right. So, but that case went to trial, and the plaintiff knew that they were in an uphill battle. However, they won $16 million. So you do risk the going and losing the big lawsuit. And as a doctor that has been through it, if you can settle less than the limits of my policy, then I'm not paying money out of my pocket. Well, I'm not paying money out of my pocket. Go settle the case. I know I didn't do anything wrong. Go settle the case. And that's what most doctors would say.
So many physicians would enter the medical legal space, and we are seeing a lot. Like there's a huge surge of doctors and legal and nurses trying to enter the space. There are, and then there are all kinds of experts. Those who are really busy, those who are in the middle of the spectrum, and those who are really trying to get work, but maybe they're not able to get that first case. And because of that, it's actually even more difficult to get cases, because when attorneys ask you, have you done any of these cases before, and the answer is no, so that breaking and getting your foot in the door becomes really important. But I want to ask you about like your observation of new physicians or other physicians. What critical mistakes have you seen others make when they enter the medical legal space, assuming that their clinical credentials will carry them?
Yeah, that's a great question. So I have a lot of my own friends that I work with now that have been interested in doing this, and I have helped them do this. I will tell you that this kind of work is not for everybody. Okay. And this is what I tell the surgery residents when they hear me talking about cases, or my colleagues. I say, you need to imagine sitting in a room across from a physician who's board certified like you, who is trained like you, who has done as many or more even of that case than you, and look at them in the eye and tell them they fell below the standard of care. And you need to back it up with evidence-based medicine based on your education, experience, and training, and the literature. If you can't do that, don't get into this field. You have to be confident, not arrogant, but you have to be confident in what you do, right? So if you can't do that, if you can't testify against another provider, you can't only do defense work. You are not credible. You're not credible if you can only do defense. I love the defense work because most doctors get sued for bad outcome and it's not malpractice, but you can't only do one. You have to be able to opine against a physician like you. That excludes a lot of doctors, because I have a lot of doctors that tell me they can't do that. But I would say the biggest mistake that somebody makes entering the field is they don't realize the amount of time it takes to be a good expert.
Yeah.
What does that mean? I mean, I'm asked to review 4 to 5 cases a month. I usually have 2 or 3 depositions a month. What do you think I do every weekend? I mean, what's coming up next week? I'm going through records. I go through every document. I take notes. You need to walk into a deposition knowing the case. You need to have the facts memorized. You need to know the case better than the attorney. If you have the facts better than the attorney, you will blow them out of the water. And I will tell you, because I have it memorized. I take notes, I have it in front of me, but I know the dates, I know the time, I know the provider, I know exactly what happened, I know the nursing notes, I know what they should have done at the time. And the attorneys don't know it that well. They know it, but if you have it memorized, they don't know it that well. And you call them out on that, it throws them off their game.
Yeah.
Because they come with a preset of what questions are going to ask
Yeah.
you, and they try to throw you off. But if, I think the last attorney I asked, I said, he was asking me a question. I said, it is sad. It's a very sad day, counselor. And he said, what are you talking about, Dr. Cohen? I know this record better than you do. It's apparent. Did you not go through this like I did? So they don't like that. Right?
Yeah.
I probably shouldn't do that, but it's really you need to spend a lot. Either you do it or you don't do it. You can't do it partially. You have to be committed. You have to be available. When the attorney calls you, you don't need 3 days to call them back. They're going to get somebody else. Being responsive and really spending the time to do a good job, because that's what they're hiring you for.
So talking about the aggressive cross examinations and like again, I mean, you said that you probably shouldn't do it, but then attorneys are attacking experts all the time, and
I
I
know.
think a little banter is healthy. It also allows the jury to see you as a human. Like a lot of experts are worried about being questioned on how much they earn as an expert witness,
Right. Yeah.
and I think juries are less and less interested in those kinds of issues. Like obviously, everybody's getting paid for the work they're
Right.
putting in, but let me ask you something. So there's a recent shift that is happening in the way depositions are being recorded. Like earlier, it was the written transcript only. But
Right.
now there are these video depositions that are happening over Zoom, and they're all getting recorded. And now there are these AI tools that are helping attorneys slice depositions and take out clips just the way they would cite a section of a deposition as an excerpt. They can now also provide like a short clip of the deposition, which shows the expert's demeanor, the way they're talking, the tone. All of that was not getting captured in the text of the
Correct.
deposition transcripts. So what's your opinion? Like, do you have a take on that? Like, will that impact how experts or you would approach depositions, knowing that okay, this is being recorded and it's not just what I'm saying on text, I'll be on video, and that video will be a part of the public record.
That's a great question. So obviously before COVID, we
Yeah.
didn't do anything over Zoom. There was
Yeah.
no such thing, right? We all did them in person. And about maybe 30% of the time, the opposing counsel who was leading the deposition wanted to have it recorded. So there is no doubt that when I know I'm recorded, I will act a little bit different. Okay. Because I can be mean and nasty on purpose sometimes, but if and when I'm going to trial, it's very different, because in trial, I'm not talking to the attorney. First of all, the whole process is different, right? Because in deposition, you have the opposing counsel who is not your friend. He or she is your enemy.
Mhm.
And it's shorter answers. Don't put yourself in a box, open ended, explain the facts, right? In a jury, you start with the direct questions. Dr. Cohen, just like an interview, how you doing? What's going on? And I can look at the jury and say, here's the story. This is what we did.
Yeah.
And then they already know you, right? They already either like you or don't like you. And juries are no different than when you meet somebody. I mean, within the first 90 seconds of me on the stand, they've already determined that they like me or not. So if I can get through that 30, 45-hour direct getting off the stand, drawing pictures, they already have an idea about me. Now comes the cross. So I have not seen to date anybody take those Zoom clips and play it for a jury. I
Mm-hmm.
guess they could, but I don't know that a judge would have to allow that. So right now, what you described, I've not seen that happen, even though I've done a lot of Zoom depositions and they are being recorded, but right now they're not being used in testimony for live trials.
So let's talk about the business of doing expert witness work. So, like, as much as some experts would not like to be seen as businessmen, but when like you step out of the profession, and I would call it an extension of the profession of being a doctor. You have to maintain, you have to be available, you have to be able to be found, and you have to have certain business processes in place so that your attorneys are not chasing you, things are not falling through the cracks. So, what are some of the systems that you have deployed to manage your expert witness aspect of your business or profession?
Yeah, and that's a great question. So again, the colleagues that I've worked with that I've helped get started, I have a whole outline for them of what they need to do, right? So thing number one, you need a retention contract.
Yeah.
You're not going to get hired from an attorney without a contract. So that's thing number one. Thing number two, you have to have an updated CV. Who are
Mm-hmm.
you? What's your background? What's your experience? And you have to have a W-9 because
Yeah.
you're going to get paid and you got to pay taxes, right? So when an attorney calls you, you got to have that stuff at the ready, send it out there. That's thing one. Thing number two, we talked about the money and being an expert, and they always ask you how much you make. When you're in deposition or trial, the thing that I've learned is, and I learned it the hard way, don't be defensive. You
Mm-hmm.
shouldn't be defensive that you're getting an hourly rate. The attorney's getting an hourly rate.
Yeah.
Every expert's getting an hourly rate. I'm no different. Are you getting paid for this testimony, Dr. Cohen? Yes, I am. What are your rates? $700 an hour. Well, that seems like a lot. What was your question? It seems like a lot. I don't know what other people get. That's my rate. I've had that rate for 5 years. Again, don't be defensive, right?
Yeah.
Right? Because I don't know what everybody rates. I don't. I don't. I think neurosurgeons make $1,000 an hour. So anyway, it's not to be defensive of things like that. So having your systems in place, number one. There's a great application or website called Wave, and there's Quicken or QuickBooks. So when you send a bill out, so when you get a retainer fee to keep track of all those things. Be very responsive to the attorney. If they're reaching out to you, call them back the next day, send them all your information right away. If you don't hear something in 2 days, follow back up. Do you know how many times I've sent somebody an email? I thought they got it. They didn't get it. And they said, "Oh, thanks for following up. We never received it. We have a firewall in our system." Oh, seriously? So, and that's just because I'm anal and I'm a surgeon. It's trust but verify. Don't assume if I'm sending you an email that you got it. And I tell you that happens a lot. And then the other question comes up about marketing, right?
Yeah.
Should you market yourself? So here I am, if I'm a new surgeon in practice and I want to do expert witness work, and I live in Richmond, Virginia, and a patient who thinks they're harmed walks into an attorney in Omaha, Nebraska, and I'm just making this up. And that attorney is sitting there and says, "I need an expert." Well, how do you link those two? How does the attorney in Omaha, Nebraska know to pick up the phone and call you in Richmond, Virginia? How do you know that? You've never done it before. Maybe you have. You've done a few cases. So you shouldn't be scared to market. I think a lot of doctors are scared to do that. There's a lot of different avenues to do it. There's LinkedIn, the social media type, mostly LinkedIn of the social media, but there's a lot of different avenues that you can legitimately market yourself that are not third parties, that don't put your hand in your pocket to take money from you, that are reputable. And there's no reason not to do that.
Yep.
And again, don't be defensive in doing that. It's marketing your services to let attorneys know, because a lot of attorneys, and every jurisdiction in the country is a little bit different. Sometimes they can't find a local surgeon to opine against another local. They have to go out. Well, how are they going to find you? If I don't market myself, they can't find me.
Mm-hmm. And you also pursued an MBA mid-career. So how did that happen? Did the business education transform your perspective on healthcare delivery, patient safety, and even your approach to managing your work and marketing it?
Yeah, so I think that was one of the best things I did back about 15 years ago. When I was chairman of our private practice hospital in Georgia, I always felt bad that I could not talk the language of the CEO and the CFO and the CO. We talked in different languages, right? I know medicine. I don't know anything about that stuff. So I decided to go back and get my MBA degree, and that was fantastic. And we classes on marketing and fiduciary responsibilities of hospital. It was hospital leadership administration. It was great. And I think back then I wasn't doing as many legal cases as I am now. I think my marketing has helped. I think I'm just getting a lot more word of mouth as the years have gone on. I mean, most of the cases I get now, probably 75 to 80% are attorneys I've already worked with in the past or in their firm, right? So an email yesterday, an attorney in my firm said they work with you and we should reach out about this case. So for me, after all these years, a lot of that now is word of mouth. But I think the MBA degree, and I'm a section chief in my current role where I work at the VA Medical Center. So talking to administration, having people under me as being a supervisor, what it means, that MBA degree, I think was invaluable.
Yeah. No, I can totally understand and appreciate that. Like just the ability to speak someone's language and to be able to use the same lingo and the jargons, I think that itself makes a huge difference in connecting with the people. So I can see
Right.
why you did that. And tell me, did that introduction to the business aspect of things, was that a factor in you getting involved with Caliver, the new medical legal engagement platform that you're working with?
Yeah, so not really. So Calivar is an interesting beast. Let me tell you about the way it works now.
Yeah.
If an attorney decides a patient's in their office and the family says, "This doctor harmed my mommy, we need help." The attorney reviews it internally. They decide they have a case, they're not sure. They need to get an expert, obviously. That's the only way the system works. About 40% of the time, when a plaintiff attorney calls me about looking at a case, I review the case and I tell them, you don't have a case. This case is a bad outcome. It is not a breach in the standard of care. Well, every expert before you review a case is getting a retainer fee. Retainer fees can be anywhere from $2,000 to $5,000 for me to even start looking at the case. That's a lot of money for the attorney. Sometimes their firm pays the fee. Sometimes they ask the patient to pay the fee, right? So it's up to the attorney how they pay the fee, but that's how the system works. Nobody's going to look at a chart until you get a retainer fee to review it. Well, 40% of the time, I tell the plaintiff attorney they don't have a case, and they may not be that happy with me. It is what it is.
Yeah.
I've been yelled at by attorneys before. Well, Dr. Cohen, can't you say this? Nah. Are you sure you can't say? Nah. It is what it is. Look, he had a colonoscopy. The perforation happened right away. They fixed it. The patient doesn't even have a colostomy. They needed one surgery. That's a known complication. Well, couldn't they have seen the perforation at the time? No. You don't normally see the perforation at the time. You usually see it in the recovery room or when the patient goes home. So things like that. So Calivar was initially started by a surgical oncologist and two attorneys that said, wait a second, think about the process. You have an attorney spending a lot of money. 4 out of 10 times, they're not going to have a case. They spend a lot of money. And interesting, they're only getting one opinion. What if we can come up with a process where you get more than one opinion and it doesn't cost you as much? That's a novel concept. So Calivar was started, 8, 9 years ago as a proprietary platform where an attorney sitting in his office can say, I think this is a case. I want to get more than one opinion from 3 or 4 surgeons. So they're able to upload into the website about the case. And it's the 30,000 foot level. It's not the whole chart.
Yeah.
It's like a curbside consult. You can upload documents, a CAT scan, operative note, you redact everything, and you throw it out to all the surgeons that are on Calivar. Well, right now, Calivar's got thousands of experts, every specialty. If a surgical case comes, if you're a surgeon on Calavar, you get an email, hey, there's a new case. Why don't you log on and see your opinion? So it's blinded. I don't know if the case is plaintiff or defense. The attorney doesn't know any of the names of the expert. It's surgeon 1, surgeon 2, surgeon 3, and you answer 4 questions. In the information we sent, was this a breach in the standard of care? Why was it a breach in the standard of care? Did the breach cause any harm? But the last question I love. The last question is, why should we select you as the expert? Great question. So now the attorney gets 2, 3, 4, 5, sometimes 7 opinions, can see all the doc. If everybody says it's not a case, they walk away for $400 or $500. Case is done. Now, let's say everybody says it's a breach in the standard of care and it's a plaintiff case. Well, they could say, ooh, I like surgeon number 2's answer. He sounds good. Now the introduction is made. The expert gets hired. The plaintiff attorney already knows the story. There is a small fee for all the experts to put the opinion in, so they're not doing it for free, so that makes the experts happy. And Calavar walks away, and the attorney then gets introduced to the expert. There is nothing like it out there where you can, for a small fee, get multiple opinions and know what you're getting into before you send Dr. Cohen a big check, and Dr. Cohen tells you don't have a case.
Yeah. No, I can see how the wisdom of the crowd, like if you're getting a confirmation from 5 different experts that there is a deviation from the standard of care, I can see how it will add to the confidence of the attorney in proceeding with the case, as opposed to,
really,
yeah.
It's interesting because even attorneys that I have worked with before have used Calavar. They use Calavar. They know me. But again, they want to get more than one opinion, which is fine. I like that. They don't want to use Stephen Cohen every single case they have. That doesn't make sense, right? So, but the last attorney that picked me, they started to laugh. They go, we opened up and we saw your name. We go, you got to be kidding me, because they used me before, but they wanted to try to get somebody else, but they liked the way I answered it. They go, okay, we'll use you. That's fine. That's fine. That's fine. That was funny.
So, do you think the anonymity changes the nature of peer review in a legal context? And like, let me just clarify my question a little. So, like earlier you told us that you reviewed a case for an attorney, and you told the attorney that there's no case, and he turned out to be a defense attorney. So your approach was pretty much the same, and it doesn't matter if it's a plaintiff or a defense attorney. When it's a blind, now maybe that's not true for other experts. Now, that's where this whole concept of the blind review also comes in, where experts are not told which party are they reviewing the records for. So do you think attorneys would be better off at disclosing which party they are representing when they are presenting the records to the experts, especially for pre-litigation review?
Well, I think so. If the question is standard of care, then I think a blinded review is how it should be done. So, and then let me tell you why I say that. So every hospital in private practice has something called peer review. It's right. So if I do something and patient is harmed, let's say I do a colectomy and it's a leak and the patient winds up with a colostomy. Any adverse event in a private hospital, not in the federal system, but in a private hospital, goes through peer review. Peer review is made up of every specialty in the hospital: medicine, surgery, infectious disease, pulmonary. It's a group that we meet once a month to go over all the complications that happen in the hospital, really to just review them to make sure there's nothing, is it a safety event? Again, it's a fiduciary responsibility of the board members of the private hospital to take care of the patients in the community. So everything gets reviewed. On some occasions, I've reviewed cases as a committee, and we felt that provider that worked in our hospital fell below the standard of care. And we've said that. But there's some conflict, right? Because we work with that provider, we see them every day, and we don't want the provider to get mad at us because it's a referral system, right? So what we do in that case is we get that reviewed on the outside. We have an outside physician review. It's completely blinded. We just send them the chart and we say, did this provider fall below the standard of care? Yes or no? So that's blinded, right? Because they know it's coming from a hospital. but it's not an attorney, and that's a blinded review. That makes more sense to me. The question of, a lot of times I'm asked specifically just for causation, which is not a standard of care issue, right? Then it doesn't really matter. Recently, I was asked to review a case where a patient was assaulted, was pushed by an employee of a restaurant, fell and hurt himself. But 2 days later, he came to the hospital with abdominal pain. CAT scan showed a perforated colon, wound up having a resection and a colostomy. Well, the question for me was, did that trauma cause the problem? So in that case, it doesn't really matter because it's not a standard of care. But I do like the idea of a blinded review. Why not? What is the downside to doing a blinded review?
I mean, I'm with you on that, but what we've also seen, and like other attorneys have told me this, and other experts have told me this, that, and I'm sure this has happened to you as well, that a plaintiff's attorney has come to you and you've told them, oh, I don't see a deviation from the standard of care. And they're like, oh, can you look at it from this angle? And can you look at it from that angle? And they would not be happy with the fact that you are telling them that there's no deviation from the standard of care. So that clearly seems to be a thing. Attorneys, I don't know if it's confirmation bias or they have, like invested enough resources into the case that they do not want to learn that they're not ready to accept that there's no standard of care and all that work and money was for nothing. Or maybe they're
Yeah,
looking for
no.
answers for the plaintiff. I don't know what the driving force is, but that's clearly a thing.
Yeah, there's a lot of different driving forces. And I've had
Yeah.
cases like that. Once a year, I get asked about a case like this where after a routine colonoscopy, the patient comes back within 1 to 3 days with severe abdominal pain and they had a ruptured spleen and they had to have a splenectomy. That is a known complication. I know it sounds weird, but there's a splenocolig ligament that just with the torque of the scope, doing everything right, I haven't had that complication yet, but I probably will at some point because I do a lot of colonoscopies. You can tear off that ligament doing everything correctly. It can bleed. Bleeding doesn't stop. But again, I've had a plaintiff attorney yell and scream at me that tell me that I was wrong, that no, you shouldn't lose your spleen after a colonoscopy. And I agreed with him. You shouldn't lose your spleen. But that's not the question. It's standard of care. I have to tell a jury the doctor did something wrong, right? Yeah. So the doctor didn't do anything wrong, but there's a bad outcome. But there's a lot of different drivers. I will tell you that the most common driver of a lawsuit is not the patient who is injured. Think about that. The most common driver, and this happened in my own cases, the patient loved me. The patient called the office 6 months after suing Dr. Cohen. And my office manager got on the phone and said, you can't follow up with Dr. Cohen. You're suing Dr. Cohen. And she said, I'm not suing Dr. Cohen. I love Dr. Cohen. It's the family. It's the family or a third party is the most common driver of the lawsuit. So there are a lot of different drivers of that issue, but you can't compromise or say something wrong. I mean, if you want to have a career as an expert witness, you have to be the one that is just telling the truth. I mean, the outcome is not up to me. When I go to trial, whether it's guilty or innocent or, a plaintiff verdict or a defense verdict, it's not up to Stephen Cohen, right? And it's very hard for the jury. And I think the whole system is ridiculous personally, because look at it from a jury standpoint. They don't have, most of them have no medical knowledge except their own interactions with their own doctors, which might not be good, right? We've all had bad interactions with a doctor, even me, right? Rectal exam with not enough lubrication. I mean, I've had all that stuff, right? I didn't tell him I was a doctor. I told him afterwards, probably should have told him before. But look at it from a jury standpoint. Very little medical knowledge. You have two well-trained experts, have been doing it for decades, good credentials, saying exactly the opposite. One say this is fine, the other said it's not fine. How are they supposed to figure that out? Right? So the ultimate outcome is not up to me. I'm just giving you the facts based on my education, experience, and training. And it's up to the attorney to put the case together to explain it in such a way that they come to the right decision. Sometimes they do, sometimes they don't. And I've had cases go completely sideways for a lot of different reasons.
So, if you had one advice for attorneys on how they could work better with experts, what would that be?
Yeah, I would say the most important thing is get the expert involved early in the case before you decide anything. I cannot tell you the number of times where I get called late in the game, even after the last, it's unbelievable. A plaintiff attorney called me to review a case, fine, sent me everything. He already deposed everybody. And he has a whole complaint list. Here he filed the complaint, filed the lawsuit, deposed everybody. And I'm reading this thing going, you've got to be kidding me. And I don't recall exactly the details. There was absolutely no case, zero case. And he was not happy with me. I didn't tell you to file the lawsuit. I didn't tell you to come up with the complaint didn't make any sense at all. And as nice as I can be, I said, sorry you got so far into the case, but if you would have talked to me earlier, I may have saved you some time and energy. But what happened was he talked to a friend of his who's a retired physician who says it's a case. Okay.
Yeah.
Okay. So get involved early, get more than one opinion, use Calivar, that's one option, or get a referral of an expert that's been doing this long enough and has the experience, because there's a lot of things that can go wrong if you're not used to playing the game of the attorneys, because it's a game to them. And I don't mean that in a negative way, but their goal is to win. And if they can win on the technicality, they can. They are trained, they have gone to school to get the answers they want out of the expert. And some are very good at it, extremely good at it, because that's what they went to school for. And they've been doing it for 20 or 30 years. So having a seasoned expert that knows the tricks and the tips to not put yourself in a box, open-ended questions, stick to the facts, don't let them don't agree to anything you don't want to agree to, because you know how the doctor, wouldn't you agree that? And then it's a long-winded question. Wouldn't you agree? They just want the yes or no. Medicine is not yes or no. There's a lot of nuance to what happens, and it depends on that particular patient on that particular time. So I think that's the most important thing, is get them involved early to help come up with a strategy of what the plan for the case is.
Yeah. I mean, only if I had $1 every time an expert has complained about being brought in too late by the attorney. We're currently helping an attorney find a forensic psychiatric expert, and he has a disclosure deadline in 2 weeks, and he's looking for a rebuttal expert. And at the same time, he wants somebody who can do it on a lien or an LOP. And that is something that again, I mean, there are all kinds of attorneys out there. So
Right.
it's so on the same note, one advice for experts when they're dealing with attorneys.
Yeah, be responsive. I mean, this may be your side job. It is not their side job. So don't take it as their side job, right? Because I'm on faculty full time. I'm busy as can be. But when an attorney calls me, unless I'm in the operating room, I stop and answer the phone. What do you need? What can I do? How can I help? So it is not their side job. And a lot of experts that do it initially stop doing it because this takes too much time. I can't deal with it. Well, you got to know going into it, it's going to take time. And, I got a call yesterday that, oh, by the way, there's a trial next month. We expect you to be here next month on the 18th in Savannah, Georgia. Okay. This morning I had to tell my office, reschedule the patients.
Yeah.
My nurse practitioner yelled and screamed at me. It's not fair. I know it's not fair, but this is part of the job that I do, right? So it's a balancing act. It's a balancing act, and it's going to disrupt. I am at the mercy of the court to decide if and when depositions. They have a whole scheduling order that all of a sudden, a case I reviewed last year, we need your deposition within the next 4 weeks. I got to find time to do that. Trials come up, things get rescheduled. I mean, the last 2 trials was on the schedule, and a week before they postponed it and it was rescheduled. One, the judge got sick. I had the plane ticket, I had the hotel, I had the time off work. It is what it is. Can you deal with that? right? It's not that easy if you're working full time. I get a lot of people at my work mad at me, but we seem to work it out always, somehow. Um, but that's the thing. This is not a side job. You
Yeah.
have to take it seriously if you want to be successful, and in doing this kind of work. And it's fun. I mean, I like this kind of work. I think this makes me a better doctor for a lot of different
Yeah.
reasons. All of these cases I review, without using the names, but the type of case, I run it by the residents. We have a similar case. What would happen if okay, tomorrow this patient drops their pressure to 50? What are you going to do? What's the workup? All right, so the CAT scan's normal. Their pressure's still 50. They're in the ICU on 2 blood pressure medicine. Now what do you want to do? Right? So it's things like that. It makes me a better doctor. It makes me keep up with the changes in medicine. Medicine has changed in the last 30 years, for goodness sake. Robotic technology, AI is changing. The copy and paste in the electronic medical record, which drives me crazy. A lot of things really, make me more aware, make me smarter, make me a better educator when I'm dealing with the medical students and residents.
I think both these suggestions were completely on point. So thank you so much, Dr. Cohen, for taking out the time. I know you're busy. In fact, we had to reschedule 2-3 times to finally find, like an hour that worked for both of us. Primarily for you, you are the busy one here. But thank you so much for doing this. This has been a great conversation. Where can people find you? What's the best way to contact you? If an attorney wants to reach out to you, how do they do that?
Yeah, so probably the best place is on LinkedIn. I mean, Stephen Cohen, Stephen with a PH. So LinkedIn, and you can maybe put it in the show notes. That's the best place. I do have a website that's just a landing page, but on LinkedIn, it has my CV, it has my email, it has my cell phone. Attorneys will call me all the time. If I'm in the operating room, I may not answer right away, but I will call you back, I promise.
Thank you so much. So that was Dr. Stephen Cohen, and thank you so much for your time. And I really hope to be able to talk to you soon again.
Thank you so much. I appreciate it.
If you found this podcast useful, remember to subscribe and give us a review on Spotify, Apple Podcast, YouTube, or wherever you listen to podcasts. This will help other users find this podcast and benefit from the insights shared by our guests. If you'd like to be featured as a guest on this show, please write to media@xlightum.com. See you in the next episode.